Hey guys, welcome to my channel. Today we are stepping into a courtroom where one divorce case turns into an intense legal battle that could change everything. Watch as both sides fight over which state has the right to decide the future of their case while the judge challenges every argument with difficult questions and unexpected twists. Nothing is as simple as it seems, and every moment reveals a new layer of this complex dispute. Stay with me until the very end to find out how this dramatic courtroom showdown unfolds.
Knopfsinger has given notice that there is a case pending in California court, and that he gives the presiding judicial officer and a telephone number. I'm assuming. Turn your microphone on the table, if you will.
Yeah, guys. Your Honor, just by giving you some history of this case, Mr. and Ms. Knopfsinger were residents of the state of Tennessee, owned property here in Dickson County, and also are property owners of a vacation home on the lake in Henry County. Mr. Knopfsinger relocated to the state of California, and in November, he filed a divorce in the state of California in Los Angeles County on an irreconcilable differences divorce. Of course, the state of California is a no-fault divorce state, unlike the state of Tennessee. California is a community property state, unlike the state of Tennessee, where we have a common law property state. He filed that divorce. My client had gone out and visited for a period of time in California with no intentions of relocating, and Mr. Knopfsinger filed the divorce in the state of California. And again, according to the pleadings, he had only been there for 5 months and 2 weeks. California requires, as Tennessee does, a 6-month residency requirement. And in the filing that he made, he actually, in the divorce filing that he made, he clicked that both he and the respondent have been residents of the state for at least 6 months and of this county for at least 3 months. And of course, it's our position that that is a perjurious statement that he has made to the California court, that my client, he still possesses, or did up until after the filing of the divorce. He did not possess a California driver's license. He possessed a Tennessee driver's license. And my client has always possessed that, and they've lived here for a period of time. They did relocate here, and they've been living here and own the property. They moved here in 2020, Your Honor. The scenario being is that there's an issue of jurisdiction to be raised in the state of California, and there's also an issue of service. Mr. Knopfsinger, through an attorney that he no longer has in the state of California, has alleged that Mrs. Knopfsinger was served. She was actually not in state when the private process server alleged to have served her, and the paperwork was found after being rained on, where it had been just laid on her porch here in Charlotte. She wasn't even in town at the time. So we have retained counsel in the state of California, and she has filed to contest jurisdiction out there and to contest service. And they are in the process of doing that. We filed the divorce. He filed in November. We filed in December. We had a number of service attempts made in the state of California. It's our position that he avoided process and in fact lied to the process server, and did not disclose who he was. At that point in time, Mr. Justin Walker had reached out to me and stated that he had been retained by Mr. Knopfsinger. I requested Mr. Walker, would he accept service of process, because in the meantime I had filed a motion for service by publication. Mr. Walker emailed me back and said absolutely he would accept service. I forwarded the documents to him, and then Mr. Walker never executed or signed the acceptance of service. I repeatedly tried to communicate to find out if he was going to serve it. The testimony will show that Mr. Knopfsinger was communicating with his wife, Mrs. Knopfsinger, who's here in the court, stating that that was just a ruse to delay and that he had directed his attorney not to accept service. At that point in time, we proceeded with the motion for service by publication, but then in the meantime, Mr. Walker filed a response objecting to jurisdiction in this court. That was he did not enter a special appearance when he filed that document. So at that point in time, I filed the motion to declare that he was served because Mr. Walker had filed a responsive pleading to that. Mr. Walker then reached out to me and returned to me the notice of acceptance, which I have now filed with the court after I filed my motion to declare he served.
Did he execute the return of service?
He did. Mr. Walker executed on behalf of his client, and that should be in the file. So that renders my motion to declare him served moot because his attorney accepted service. So once I filed that, then I proceeded to file my Condante-like motions that are before the court. A motion for spousal support, and correspondingly or alternatively, a motion for division of the marital debts, a motion for exclusive possession of the marital residence, and a request to go on and place the vacation home, which is the house on the lake in Henry County. We wanted to go on and get permission to sell that. Yesterday, I received from counsel a motion to strike all of mine motions, pending on the ruling in California as to whether or not California had jurisdiction. It is not disputed, Your Honor, that he filed first in California. What is disputed is that he had not been a resident of California, or she had not been a resident of California at all, and that there is no in-rem jurisdiction in California to dispose of real property in the state of Tennessee. Of course, they have in personam jurisdiction over Mr. Knopfsinger, who is now living there, and who now has lived there for over 6 months. But again, they can only order him to do something as it relates to the property, but he would have to come back here and to execute, and we would have to file, if that court ruled on anything relative to Tennessee property, then again, it would have to be, that out-of-state would have to be filed and perfected here so that full faith and credit could be done there. So it's our position that these parties are property owners in the state of Tennessee, that the facts that led to the divorce occurred in the state of Tennessee, and that Tennessee is the proper venue to proceed on the divorce. And when I got the motion to strike, I communicated with Mrs. Knopfsinger's attorney in the state of California and got the requisite information for Your Honor to, if Your Honor is inclined, to contact the California judge and for y'all to make a determination on which is the appropriate forum. It's not like under the UCCJA if you had children involved, but still it's an issue of in personam jurisdiction and in rem jurisdiction that both courts have to determine. And again, secondly, Your Honor, is that Mr. Knopfsinger is not present in court. I've received no notice, which is required under Tennessee Rule of Civil Procedure 43.01, so we would object to his participation via Zoom. Your Honor, it has to be, of course, starting July of last year, Supreme Court modified the rule that there has to be a request for any witness who is going to offer testimony. Of course, he can listen in, but for him to offer testimony, he would have had to file under 4301 to ask permission as a witness to testify via electronic means, and that has not been done. I only discovered that he was not going to be here when I was talking with the clerk just before court started that said that Mr. Knopfsinger had requested to appear via Zoom, and of course, that hasn't been ruled on, and I wasn't given adequate notice.
You have a response?
Yes, Your Honor, if I may. May I press the podium?
You may.
And I apologize, Judge, I know you want us to, but I have, with my hip surgery, it's easier for me if with
I don't have any
permission.
problems unless you're questioning a witness,
Yeah.
with you remaining there. As long as the microphone's turned on, there shouldn't be a problem.
Yes, sir, thank you.
Well, thank you, Your Honor, and nice to meet you. My name is Attorney Michael Talley. I am not attorney of record for Mr. Knopfsinger. That is Mr. Justin Walker. I am here in his stead this morning, and we'll try to attack this in parts here. Number one, we're going to address the situation regarding Mr. Knopfsinger's appearance today, Your Honor. Obviously, as you've just heard, he lives in Los Angeles, California. These motions were filed on April the 4th, and in order to obtain his physical presence here on such short notice, it'd obviously be Herculean feat in that of itself. There's no prejudice that would come to the wife if you were to participate and if any testimony were to be offered by him today in this matter. So we would ask that he be allowed to participate in full if any testimony is needed by him. Secondly, The threshold issue in this situation seems to be whether or not the court should and could rule on the motions that were filed by opposing counsel due to the dual jurisdictions that have attached here in this situation, Your Honor. Mr. Walker filed yesterday with the court, as opposing counsel indicated, a response which indicated case law and also common law that supported the argument that at the very least these motions that were filed by opposing counsel need to be stayed, and at the very most need to be quashed and dismissed entirely, Your Honor. I'm sure the court is well aware of the prior suit pending doctrine. It's not anything new. I'm sure opposing counsel knows about that as well. You'll see in the filing from Mr. Walker in paragraph 7 that a case is listed which offers some guidance and precedent on what the court should do in this situation. It says in paragraph 8, the prior suit pending doctrine is derived from an ancient common law rule prescribing that a person shall not be twice vexed for one and the same cause. It goes on to list and note another case that the court has ruled on called American Lava, where they say, not in large part, that a case is officially pending whenever there was an action that's filed in that particular jurisdiction. It said, this holding strongly implies that the pendency of an action begins with filing. Our opinion in American Lava, therefore, can be read to support beginning the pendency of an action either with filing or with service. This holding strongly implies that the pendency of an action begins with filing. Our opinion in American Lava, therefore, can be read to support beginning the pendency of an action either with filing or with service. In this situation, in this case, it said Mr. West's suit in Smith County became subject to dismissal because there was a prior suit pending and a court having jurisdictions over the parties. Therefore, the Smith County Circuit
Wouldn't that
Court-
be the preeminent consideration, the court having jurisdiction over the parties?
Yes, Your Honor.
Doesn't matter. Let me just give you an example, and I want to give you every opportunity, but let's say that husband and wife live in the state of Texas or the state of Tennessee. We'll just say the state of Tennessee. He relocates to California and one day later files a complaint for divorce. Then the wife files 2 days later a complaint for divorce in Tennessee. Who has jurisdiction?
I guess that would be a fact-dependent situation, Your Honor.
I understand, that's the very issue that's before the court. Filing a complaint for divorce, if you're not within the time limit for the jurisdiction to acquire, the state of California to acquire jurisdiction, which is a 6-month residency requirement, just like here, then my example is an extreme one where he's there one day and files for complaint. Clearly, he would not have jurisdiction. California would not have jurisdiction, but it's a prior pending suit. So the fact that there's a prior pending suit, in your argument, are you saying that the mere fact that there's a prior pending suit, even if there's no compliance with the residency requirement, would prevent this court from being able to consider anything in this case?
No, Your Honor, I wouldn't say that's my argument entirely here. I'm not aware or not if the court has a copy of the California petition that was filed by Mr. Knopfsinger, but obviously it alleges that he was there for the required amount of time in order to file such a complaint. There is a hearing scheduled based for the jurisdictional aspect of the validity of this situation that's taking place at the end of May, I believe. Wife has hired an attorney there. Mr. Knopfsinger has an attorney in California in order to figure out what the situation is.
Let me pose another question. I'm sorry to continue to interrupt you. Let's assume that California rules that they have jurisdiction, and I determine that they don't have jurisdiction because, in my opinion, Tennessee was the home state of these parties when they separated at the time of their divorce, based on evidence presented to me. Then what? They say they have, I say they don't. I say we've got it.
Your Honor, those are the hard questions that the court has to tackle every day.
I could give you an example of a case like that. When I was just a young lawyer practicing, I came back from the University of Houston in Houston, Texas, where I had my Texas law license, but I came back and started practicing in Tennessee, where I grew up. And there was a case that I was doing some research over, the issue of jurisdiction. You're too young to remember Justice Joe Henry, who was one of the appellate court judges that we had many years ago, but he had quite a sense of humor. I mean, the question in that particular case that I found during my research was the question of whether or not Tennessee had jurisdiction over a divorce in a child custody case, or whether Texas had jurisdiction over this divorce and child custody case. And after going through, and the trial court in Texas had ruled that they had jurisdiction. The Tennessee trial court ruled that we have jurisdiction. The Texas appellate court upheld and said Texas has jurisdiction. The issue was then presented to Justice Joe Henry, and he opined, among all of the reasons why Tennessee had jurisdiction and all of the technical legal reasons why Tennessee had jurisdiction, and he finally said, and as for our brethren on the Texas Court of Civil Appeals, I would say, in their opinion that they have jurisdiction, I would simply point out to them that were it not for the state of Tennessee, the sovereign state of Tennessee, Texas would still be a Mexican province. And so he upheld the fact that Tennessee had jurisdiction. My point of that is, and it's a little bit off base here, my point of this whole story is that it's just the fact that he filed a day or a month before she filed in the state of California does not necessarily mean that they have jurisdiction preeminently over us, nor does it mean that they don't. What it means is that there is a factual issue to be determined as to where venue lies, where the residency lies, and where jurisdiction lies. And for that reason, it seems to me that whether they have a hearing scheduled in the state of California in May is not going to prevent this court from hearing whether or not this court has jurisdiction, in my opinion, and therefore then the state of California can accept what I say, or they can litigate that they have. But they're not bound by my ruling, nor am I bound by their determination whether they have jurisdiction or not. So that's the issue that I wanted to present to you. But I've interrupted you numerous times, and I apologize for that, but please feel free to go for it.
No problem, Your Honor. You said that was Justice Joe Henry, you said?
Joe Henry.
I'll write that down then, Your Honor. Our argument is based upon that there was a legal and factually accurate complaint that was filed in California with all the statutorily required things that California needs that are complied with in that complaint, Your Honor. If the court sees fit to hear evidence today to determine whether or not this court has jurisdiction, I would understand that. However, out of an abundance of caution, I think that the situation might need to progress a little bit more to see what California even says. And based upon all that, Your Honor, I would ask that the court stay or dismiss the motions that were filed by wife in this case. And if the court requires hearing, we're prepared to do that today as well.
Well, let me ask you then to address the issue of Ms. Roberts has raised an objection to your client being allowed to testify today because he's testifying remotely. And the new rule 43.01 of the Rules of Civil Procedure does provide certain requirements that have to be met if that is going to take place. And her allegation is that there's no motion been filed to allow him to testify remotely as required under 43.01. And there's no order that allows that to take place. Do you have any input on that particular point?
Your Honor, if memory serves, I believe by the letter of that law, these types of things have to be filed within a certain amount of time too. I forget if it's 30 or 60 days, one or the other. Given the date that the motions were filed, and given that today we're having this hearing, I believe the motions were filed on April 4th, it's the 17th. Even if Mr. Knopfsinger wanted to comply with that provision of the law by the letter of the law, he would still not be able to do so because of the quick turnaround from the filing of the motion and today's hearing date, Your Honor. Again, he lives in California. I'm not acting like it's impossible to get here in that time, but we all know that life happens and it's not always as simple as jump on a plane, go 1,000 miles for a court hearing, Your Honor. So I also would aver that There's going to be no prejudiced parties by the participation of Mr. Knopfsinger. All he would be able to do is add more clarity to the court on what decision that they should make today. So we would ask that his participation be allowed for the purposes of offering evidence to this court to make its decision.
All right.
Thank you, Your Honor.
Brief reply, Your Honor. Brief reply. Your Honor, what I would do is I would request, Your Honor, to go back and look at, I don't know the date that it was filed with the court, but in the court file, Mr. Knopfsinger, through his counsel, filed first of all, the defendant's objection to jurisdiction. That was the initial thing that was filed. It was certified on the 19th of March to me. I apologize, I didn't get a stamp filed copy.
Well, let me find it here.
As you're looking, because after I got this, it was certified to me on the 19th, and when I received it, then that's when I filed my motion to declare service. Which was filed on March 21st, so.
You said it was March 21st?
That's when I filed my motion to declare service, so this document should be found.
Yes, March 27th, 2025, a motion, defendant's objection to jurisdiction. I have it before me.
Okay, so I had received that, and I guess I hand-delivered my motion to declare service before that got filed with the court. But at any rate, if you look at that, Mr. Walker is an officer of the court, and of course, it was that we can take as true. It's not signed under oath by Mr. Knopfsinger. But if you will look at paragraph 2 of that, plaintiff alleges being a resident of Los Angeles County, California for 5 months and 2 weeks prior to the filing of the aforementioned California case. And that's what our position is that the parties, he moved out there actually.
This courtroom battle proves that the most important question is not always whether a marriage is ending but which court has the legal power to decide the future of the case. As both sides challenged each other with different claims and evidence, the judge carefully examined every argument before moving forward with a decision that could shape everything that follows. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.